Jill Ovens is the National Secretary and co-leader of the Women's Rights Party of Aotearoa, New Zealand, and a former union leader of 36 years. She attended the University of Auckland in the early 70s when women's liberation was very alive. Germaine Greer spoke on campus and had a big impact on her. Throughout the 1970s and 80s, she lived in the US, where she campaigned for the ratification of the Equal Rights Amendment to the US Constitution that would explicitly prohibit discrimination based on sex. She has held multiple positions, such as Senior Lecturer in Journalism at Auckland University of Technology, where she was also heavily involved in unionism and women's rights. With 20 other women, she founded the Women's Rights Party in April 2023, within days of the violence at the Auckland Let Women Speak event at Albert Park on the 25th of March. The party currently has around 750 financial members, including men as well as women. The Women's Rights Party was registered as a political party on the 28th of August 2023 and subsequently contested the 2023 general election with a list of 12 women. Jill, go ahead.
Right, so kia ora everybody. We made a joint submission into that Law Commission review as well as the Women's Rights Party and WDI New Zealand, and we've also recently submitted on a revised Improvements for Surrogacy Arrangements in New Zealand bill. So the original bill was introduced in 2022 as a members' bill, and I'll come back to that bill, and it was accepted by the then Labour government to proceed, but then there was the election at the end of 2023, in fact just a year ago, and it could have been quietly dropped by the incoming coalition government, but instead a revised bill that's been to the Law Commission is being considered by the Select Committee, and that's what we were making our submission on. And I think the reason why it's still around is because of the influence of the Libertarian ACT Party, and in fact it's been sponsored by Nicole McKee from the ACT Party, which is what we would describe as a far-right party. So the Women's Rights Party, we have explicit policy on this. We oppose commercial surrogacy due to the potential for exploitation of women, and we think that commercial surrogacy should remain illegal in New Zealand. We also, along with the Women's Declaration International, reaffirm that motherhood is an exclusively female status. So in the UK, 1 in 5 parentage orders in relation to surrogacy are either for gay male couples or single men. And we would say, by definition, they can't fulfill the role of mothers. So the Women's Declaration International, their position is, or our position, is that we reaffirm women and girls' rights to physical and reproductive integrity, and we oppose the exploitation through surrogacy and related practices. And so if you look at WDI Article 3, it talks about harmful practices such as forced pregnancies and commercial or altruistic exploitation of women's reproductive capacities involved in surrogate motherhood, and that these should be eliminated as forms of sex-based discrimination. So both the Women's Rights Party and WDI also oppose international surrogacy. In our submission, we asked whether having a biological child is a human right, and we asked whether this would imply a societal duty to provide babies to people who can't have their own children. And we questioned about the child's human rights, as well as safeguards that are in place to ensure babies aren't being commissioned by paedophiles. And then we asked, is it ethical to commission a baby with the deliberate intention to bring it up without its mother? So our submission covered the current situation, why we oppose the original bill, changes in the revised bill, transferring parentage from the birth mother to the intending parents, international surrogacy, and Suzanne was talking about the 80 questions that the human rights that the Law Commission asked in the human rights submission that we were supposed to answer. Well, this one was similar. It had a whole range of questions which we chose by and large not to answer, and then we told them about questions we thought they should have asked, but they didn't. So the current situation is that when a baby is born to a surrogate mother, either in New Zealand or overseas, the intending parents must apply to adopt the baby after the birth in order to become the baby's legal parent. So we support a process that allows the birth mother time to reconsider her decision following the baby's birth, and our view is that the current adoption process does allow for this. So the surrogate mother, surrogacy arrangements are legal in New Zealand. You can make arrangements, but currently these arrangements are not legally enforceable. So in other words, it's not against the law to have such arrangements, but a person cannot go to the courts to get the courts to enforce whatever was decided by the people involved when they made the arrangement. So the surrogate mother is automatically the legal parent or caregiver of the child she's carrying. And the intending parents have no legal rights to the child before or after the birth unless they adopt the child. So even if there's an arrangement with a surrogate mother for intending parents to adopt the child after birth, a surrogate mother who wants to change her mind and cancel the arrangement, she can do that and raise the child herself under the current legislation. And as of now, a surrogate mother cannot be forced to give up the child, even if the baby's conception involved donations of sperm or eggs from one or both of the intending parents. So you can see here what the concern is about for the intending parents, because they want to protect their legal status. But in our view, the rights of the birth mother and the surrogate born child must be the prime concern of the law. So in 2022, Tamati Coffey, who was a Labour MP at the time, and he with his partner Tim had 2 children born via surrogacy. And they lodged, or at least Tamati did, lodged a private members' bill. And the aim of that was to simplify surrogacy arrangements, to ensure completeness of information recorded on birth certificates, and to provide a mechanism for enforcement of surrogacy arrangements. So you can see why we would oppose that bill. I spoke to Tamati at the time that he was getting that bill ready to introduce, and it was his view that the adoption process was too long and didn't provide the necessary support for the intending parents. So we opposed that original bill because it would have provided the intending parents with automatic legal status at the point custody was transferred, which is often at the birth or very soon after. And the intending parents would have all the rights and liabilities as parents of the child. And if the mother didn't hand over the baby, they could apply to the court to enforce the surrogacy arrangement. And the birth mother must transfer then the parentage within 10 days of the birth. So it did not protect the interests of either the birth mother or the child. And it failed to recognise that the unborn child is already interacting with his or her birth mother in utero. And that's both physical and psychological. As well, we believe that the Tamati Coffey Bill breached the United Nations Convention of the Rights of the Child, which of course proclaim that children are entitled to special care and assistance, including appropriate legal protection, both before as well as after the birth. And the family is recognised as a fundamental group of society, and the natural environment for the growth and well-being of all its members, and particularly children. And therefore, families should be afforded the necessary protection and assistance so they can fully assume their responsibilities within the community. And Article 3 of that United Nations Convention of the Rights of the Child states that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be the primary consideration. And this is what, when the Law Commission looked at the coffee bill, this is what they found as well. And they made a number of suggestions which are now in a redrafted bill that that's being considered by the Health Select Committee, and that's what we were making our submission into. So the Law Commission, though, did describe surrogacy as a unique method of building a family. But in our view, the autonomy and rights of women undertaking pregnancies and birthing for surrogacy purposes need to be taken into account to avoid discrimination and exploitation. And so in our submission, we quoted journalist and author Julie Bindel, who says that there's never much consideration for how a surrogate mother, either financially motivated or as a volunteer, may feel when the time comes for her to hand over the baby she's carried for 9 months and has just birthed. And she says that she's actually talked to many women in this situation and found that when they enter the surrogacy arrangements, they convince themselves they'd merely be carriers, and that's how it's pitched. But they eventually found themselves traumatised and devastated by having to give the baby up. So despite our reservations about surrogacy, we did support the changes that put the child at the centre. And we think that one part of the bill is about surrogate-born children being able to access information about their genetic and their gestational origins. So in New Zealand context, that can mean their whakapapa, which in Māoridom traces back their origins, and that information should be made available, and we've said that it should relate to both the birth mothers and the donors, hapu and iwi, which are levels of structure within Māori society as part of the ethnicity and cultural affiliations that might become important for the child in future years. So it's not just about genetics in terms of health. So we also thought that it was a good thing to tighten regulations around surrogacy services because there has been a huge increase in the number of surrogacy services in New Zealand. So commercialisation of surrogacy is technically illegal in New Zealand, but the involvement of fertility services in surrogacy services through assisted reproductive technology is a commercial activity. And someone has to pay for that, and that's be it the intending parents and the surrogate mother who gets reimbursed for her costs. So we're concerned that although commercial surrogacy is illegal in New Zealand, fertility services that provide surrogacy services are a booming industry here, as we see from advertisements on TV and Z. And someone has to pay for these privately provided services, which won't be cheap. And ultimately, it'll be those with the means to pay who are exploiting those without, that is, the surrogate mothers. And we note from a previous feminist question time with Helen Gibson from Surrogacy Concerns in the UK that the number of surrogacy arrangements has risen rapidly with the widespread use of assisted reproductive technology there. And where in the 1990s most surrogacy arrangements would have been with women who couldn't have their own babies, now many of those seeking surrogate services are gay males or single men. And more than half are well past childbearing age. So of the 500 plus parental orders in England and Wales in 2023, 293 were to couples or single intending parents aged 50, over 50. and 43 were over 60. In fact, there was one man who's 72. So one has to seriously question in whose interest does this serve, the intending parents or the child. The other thing that is part of this is the issue about egg harvesting, which has been promoted by fertility of equality and career progression for women. In other words, you can have your eggs harvested, you can get on with your career, and then when you hit the age where you're not likely to get pregnant by the usual means, there's eggs that have been harvested and embryos ready to be implanted. So what happens is this bill does restrict harvesting eggs from minors, and the ethics committee can cancel approval for a surrogacy arrangement if the procedure poses a serious risk to human health and safety. And we do support measures to protect the health and safety of the surrogate mother. In New Zealand, it is quite common for altruistic arrangements whereby somebody will agree to have a baby for her sister or somebody else in the family, and then following the birth, the baby goes to those parents. But usually, and this can be really successful, usually where there's continuing contact and there's transparency about the arrangements that have been made. However, as Bindle reports, she's met many women who've been severely traumatised by their experience as surrogates' mother. And she says, we rarely hear from them. The surrogacy industry and its many supporters focus their attention on the feelings and desires of the commissioning parents, and they fail to pay any attention to the suffering of the women who make all this possible. So the process that's been put forward in the revised bill is a process called operation of law, which instead of being an adoption process, the mother signs a statutory declaration in the presence of a lawyer, and that's simply recorded by the court. But you can't do that, according to this bill, for 7 days till 7 days have passed after the birth. Now, we didn't think that was long enough, and we suggested 2 weeks, but we changed that at our oral submission and said it should be 6 weeks, which is in line with what's in the UK. So the thing about it is that a change has been made where the birth mother is the sole parent until the parental rights have been transferred. Even if the birth mother has a partner, previously her partner had to have a say as well. And we did not support the idea that was put forward in the revised bill of shared guardianship with the intended parents before transfer. We do think that it's really important that the mother makes a decision that she can live with. So moving on to international surrogacy, and we recognise there are really significant legal, social and ethical issues. We heard from Helen Gibson that UK surrogacy brokering services are operating in the UK with countries where commercial surrogacy is legal, even though in the UK, commercial surrogacy is illegal as it is in New Zealand. And so what's happening is that countries where there are weak regulations and poor health services, where the surrogate mothers live, the mother and the babies are vulnerable, both in a human rights context as well as a physical context. So Julie Bindle, again, we quoted her that she says that the surrogacy industry is built on the commodification of the female body. It can never be truly free from exploitation. And she goes on to say, in places where for-profit surrogacy is legal, from California and New York to the Ukraine and Mexico, disadvantaged women are being turned into wombs for hire with no consideration for their human rights. In these jurisdictions, where surrogacy is seen as a simple business transaction, the surrogate mother is often required to sign an agreement which gives commissioning parents pretty much complete control over her life and body throughout the entire pregnancy. These women are left to deal with any pregnancy-related health issues alone after the baby's born, and often find themselves settling for far less money than what was originally agreed, especially if there are complications or if a miscarriage occurs, which it frequently does. And there was a really excellent Australian TV foreign correspondent, don't know if any of you in Australia saw it, where babies born with major health problems such as brain damage have been left abandoned in the Ukraine by the commissioning parents from the home country, where the social services and health system are ill-equipped to deal with them. So what happens in New Zealand is that we have regulations around bringing the children back into New Zealand. There's no automatic right to enter New Zealand for these surrogate-born children, even if the parents contributed genetic material, like a sperm or an embryo or an egg, and the children have no rights to citizenship, so they're given a temporary visa, and then they have to go through a process in order to get their citizenship. And until they do that, they've got no legal rights for inheritance or any of those sorts of things. And we note that some countries have banned commercial surrogacy, and that these include Thailand, Nepal, India, and Cambodia. But in her presentation, Helen Gibson said Thailand and Taiwan are considering opening their doors, which would be very serious for those of us in Australia and New Zealand, because it would be a lot easier to go there than some of these other countries for our people. We noted that there was no data available on surrogacy in New Zealand because it's an adoption process, so the data is mixed up, and there's no provision in the revised bill for that. So just to make it clear, as I finish up, we unequivocally oppose international surrogacy, and we've also called for a ban on the export of eggs or embryos by a New Zealand fertility clinic for the purposes of commissioning a commercial gestational surrogacy. And these are the questions that we told the Select Committee they should have asked. Can surrogacy ever be free of, whether it's commercial or altruistic, of exploitation of a woman's reproductive capacities? Secondly, can we ever eliminate the coercive element inherent in the practice of surrogacy? And even in New Zealand, where commercial surrogacy is against the law, do we have a situation where those with means can essentially buy a baby to be carried and birthed by women who become a commodity in a profit-driven transaction? Then we asked, do modern reproductive technologies used in surrogacy create so much risk of harm that permitting them for this use should be banned? And should traditional surrogacy be less restrictive? Because currently it's only allowed for sisters and cousins. So we asked the question I talked about before, is having a baby through surrogacy really a human right? Should couples or single parents in their 50s or 60s be allowed to commission a baby? And should we ban international surrogacy by New Zealand citizens? And then we ask, could growing a new life in your womb, birthing that life with great risk to your own well-being, and then handing a baby over to the person who commissioned it, ever be considered just another type of work? And that's a quote from Julie Bindel. And we did leave the last word to her. Those gushing about the joy that surrogacy brings to the lives of commissioning parents and claiming it as a human right to have a biological child should take some time to consider the many wrongs being done to the women used as surrogates. And we would add, and to the children. That's me.
Thank you, Jill. That was chillingly awful, as it always is on surrogacy, but thank you so much for your work and clear explanations.